A building went up in flames midway through a floor installation project. After the owner refused to pay the contractor, the court answered a burning question about partial performance of a contract in Carroll versus Bowersock. J.D. Bowersock hired Martin Carroll's construction company to build a new reinforced concrete floor in one of Bowersock's warehouses. Under the contract, Carroll would provide all the material and labor to remove the old floor and install the new one. Then Bowersock would test the floor. Carroll removed the old floor and installed concrete footings. Next, Carroll put floor rods in the warehouse, but they weren't attached to anything. Also, he built temporary columns that would be filled with concrete. The warehouse burned down. Neither Carroll nor Bowersock caused the fire. Bowersock decided not to rebuild, so Carroll couldn't complete the project. Carroll wanted Bowersock to pay for the expended labor and materials, but Bowersock refused. Carroll sued Bowersock. The judge estimated the value of superintending the work and using Carroll's tools. Then the judge added these to the actual expenses, like the workers' pay and construction materials. The court awarded Carroll almost $700. Bowersock argued Carroll couldn't recover for his partial performance on the contract and appealed to the Kansas Supreme Court.